Carl.
Thanks, Chair. Chair, I've got a few questions on the ACCC submission to the RBA inquiry on payments and surcharging, if that's okay.
Yes.
Thank you for writing submission. I think it's really important that your views are considered by the RBA. Just going to some of your comments in there, you mentioned that most reports that are made to you, and I do note that there's quite a few reports in the last 18 months, they're concerning alleged excessive surcharging, but you do note many consumers lack access to cost data to verify whether a surcharge is excessive. So when someone makes a complaint, what is the process that the ACCC goes through to verify that complaint?
So we have a process of review in order to look at complaints that are referred, and we look at the impact that that conduct is having. There is an obligation on the acquiring bank for each merchant to provide the merchant with the costs of acquisition, basically the costs of service to them for the purposes of the credit card, debit card transactions. At times, and we did indicate this in our submission, so what we know is that consumers look to the estimates and the range that the Reserve Bank has put on its website of what the costs will be. And they are only estimates, and there is quite a wide range of those costs. Roughly what the ACCC is aware of and has put in the submission, larger merchants are in a better position to achieve lower cost services from their banking provider. And so at times what we find is actually consumers believe it's overcharged, but actually the costs were reflective of the charge. That does not mean that's always the case, but quite often it is the case. What we do see, and as we've put in the submission, Australia, and we think this is a significant benefit for Australia compared to what each of us would have experienced when you're in the US or you're in Europe or the UK, where there are multiple other fees and charges that are included on top of the represented price. We largely have a single price, a unified price approach. These surcharges are an exception to it. And for instance, the government made that decision quite some time ago when introducing the GST, that it should be a price inclusive of GST. So consumers would not be confused. The price that was advertised or up on the board at the coffee shop is the price you're actually going to pay. Whereas actually now, then there can be quite often poor disclosure. And so we those sorts of aspects we wanted to draw out in the submission, that the current regulatory framing is actually in part confusing consumers, and we have recently received from the government funds to take more compliance and enforcement action. We are carefully working on that because we have taken action in relation to overcharging where it was, for instance, with large ticketing supply companies, where it were large companies. It is difficult when we see much of this behaviour is large number of very small merchants. And so we are looking at an education campaign and a compliance campaign and in effect warning process in order to make small and medium-sized merchants aware of their obligations here. The head of our Consumer and Fair Trading Division has come on screen, so I will, Mr. Gress, Rami Gress, I'll give him an opportunity to also add there.
Thank you, Ms. Gottlieb. I just want to draw out one point that raised, and that is it appears to us consumers are particularly concerned and upset when they do complain more about the lack of disclosure, or equally as much about the lack of disclosure at point of sale as they are about having add-on costs that they feel are unfair. So in terms of that compliance and education and ultimately enforcement piece, we'll be tackling both of those elements.
Right. So I might just maybe rephrase my question because I'm still not clear of what the process is. So if someone makes a complaint, they're at a small business, and someone makes a complaint of the 2,500, just pick one. What happens with it when it gets sent to the ACCC?
So we've got a process by which we triage all complaints, and those complaints are assessed against our priorities, and then are applied to either if it's in an area such as this, which is a priority, it would be applied to either a compliance or an enforcement perspective. There would be a investigation, most likely, of the circumstances of the complaint, and it'll then be put onto a track as appropriate.
Okay. And do you investigate all the complaints?
Well, I mean, it's worth bearing in mind we receive at least 100,000 complaints a year, so there has to be a triaging process. But currently, because surcharging is an important issue for us, we would look into each and every complaint that we thought prima facie could potentially breach the Act. Not all of them do. Often we hear that people are upset that a surcharge is added on to the purchase, and that's understandable. However, it doesn't necessarily disclose a breach.
Yeah.
So we do assess every single one of them because they are in an important area for our policy setting.
Okay. Do you think that you did highlight transparency of costs to the consumer? Do you think that lack of transparency, I guess, is stopping consumers understanding whether or not they're being excessively surcharged or not? Like how are we meant to know whether? Yeah.
It is certainly one of the factors. Go ahead, Rami.
Oh, yes. I was just going to say the same thing. It is indeed an important issue, because if you're not aware that you're going to be charged and it's not disclosed to you clearly, it's very hard to make an assessment, firstly, whether you want to make the purchase, but also whether those charges look reasonable. So the two do go hand in hand, and as Ms. Cass-Gottlieb said, this skews towards smaller businesses and micro businesses in a lot of cases, and so there is going to be a necessary element of education and compliance messaging, so they understand their obligations to consumers in this process, and also what their obligations and rights are under the law. Once we undertake that exercise, we'll then look for whether there's non-compliance and take appropriate action following that.
One of the issues identified by the RBA in their issues paper is the blended merchant pricing. You're aware of that term?
We are.
Okay, great. So, and this is all public data. Costs associated with debit cards are significantly lower than costs associated with credit cards, both the ones charged out to consumers, to small businesses, and businesses. But what happens with blended rates is that you get charged this uniform price. So I guess I want to understand from you, as the organisation, the entity charged with enforcing excessive charges, how are blended prices not considered excessive charging when debit costs are low to the payment provider, right, at 0.2 or 0.3 or 0.4%. So the payment provider, that's what they get charged. But the small business gets charged 1.6% as a blended price. And then obviously the small business passes on 1.6% when it's publicly known knowledge that debit cards charges cost less. Have you had that proposition tested, or is that something that you've considered before, that blended pricing is excessive pricing?
So there have been, and a number of them are public submissions to the Reserve Bank review relating to these questions, but just looking at it separately, we have also had matters raised with us relating to this. There is a complexity here in the current regulation because the obligation not to charge higher than the costs sits at the merchant under the law. It does not sit in the payment service providers who are giving that service to the merchant and who are receiving services themselves up the chain, either from banks or from schemes.
So if a small business complains about being overcharged for debit, you can't investigate that?
So, correct. Actually, we can't, because there is not a price that obligation to only charge a cost reflective price, which, Mr. Laxale, you're really asking us, and I understand that question. That obligation does not apply to the payment service providers currently under the law. The prohibition currently that was put in the law by the previous government that the ACCC enforces applies to the merchant, does not apply to other participants in the services chain.
Do you see the issue here, though? Like when debit costs are so low but they're being charged much higher, like is this the nexus of the problem here?
It is an important part of the problem. And one of the reasons in our submission we wanted to draw attention to these questions is there's a possibility that if, for instance, there were to be a prohibition of charging any surcharge by a merchant for a debit transaction, but not a credit transaction. So say it only applied to a debit transaction, but that prohibition does not apply to other participants in the chain, the merchants would be in small merchants particularly, would be in a very precarious position because they would continue to be charged a blended rate fee.
So you've never, just to clarify, you've never been able to undertake an investigation into payment providers like banks or those third-party ones in regards to the costs that they charge to businesses?
Unless they were being misleading or deceptive, which has not been raised, or it was suggested there was some anti-competitive element in the conduct in setting it. It is not within our powers, actually. There are elements of regulation by the Reserve Bank of levels of fees, but they are generally sitting in the credit card. And sorry, I'm just going to get the light back on in here. In the credit card and debit card scheme level, rather than in these intermediary payment service providers, which is actually an important point about the importance of the proposed amendments that are in the bill for the Payment Systems Regulation Act, because they expand the definition of payments providers to those who provide services in relation to it. So there is already, it has just been because of the backlog of passage of legislation, but there are amendments proposed there that would expand the jurisdiction, and we think very important, expand the jurisdiction of regulation, but currently that is not the case at this time.
I just popped on your website and had a look at your media releases for enforcement of this stuff, and the last one I could see was in 2021 for Nine Entertainment. You did again refer to that number of 2,500 since January 23 to June 24. Is that accurate? That last enforcement you undertook ended in 2021. Has there been any more recent than that?
I can confirm that's right. There has not been any since then.
Why is that?
But there have been investigations, Rami, and investigations do prompt awareness of compliance. Whenever a business is investigated, they become much more focused. So there has been activity, but largely that has been in the context that most larger businesses are compliant, which has also been the observation that it is coming through in other reviews. And so we are always looking that our enforcement actions are proportionate to the size of business, proportionate to the impact, which is why we are framing this new program very specifically in a compliance and education framing for the very small and micro businesses.
Is the fact that the payments, I mean, how many of your investigations and compliance is just simply the business not understanding what their costs are? Like, do you have to make those determinations between complex, like it being deliberate and known versus giving a bit of leeway for a misunderstanding? Does that happen often?
So one part I'll just answer in principle, and then we'll allow Mr. Grist to supplement. One of the key elements in proportionality that we look to is both size of business, its knowledge, how intentional is conduct. So each of those are important parts in when we determine whether to take action, what type of action, and if we are seeking redress, what is appropriate redress. And it is all quite carefully also explained actually on our website how seriously we take that those questions of proportionality. But Rami, would you like to add something as well?
Yeah, that's correct. And I'll go back to the point I made earlier, which is while we do receive complaints, many don't bear any contravention under the Act or likely contravention. So, as I say, people are upset about surcharging. We see non-disclosure issues and often, so to pick up the point about proportionality, we will write or engage with the trader because they are usually small and unsophisticated. And I think it's those observations that have led us to the view that a compliance and education first step is important, so that businesses do understand what they do need to do, not just from charging the right surcharge, the correct surcharge, but also in terms of disclosure and transparency.
Okay. So in October, you were given $2.1 million from the government to enhance enforcement efforts. How have you used that money? Is that just more compliance officers? How have you used it?
It's going to be a combination of staff that are able to engage directly with business through a media campaign, an awareness campaign, and potentially guidelines. So there's that component of the work. There will be an outreach element with respect to the relevant peak bodies, of course, and other media channels. And then the complementary piece will be enforcement resources to then ensure that businesses are doing the right thing after the initial campaign. So it's both staff and the associated costs with the campaign itself.
I've got two more questions, Chair, if that's okay. This is obviously not a new problem. I understand why in October you're given more resources. You probably asked for them, given the spotlight on this from August last year. What did you do before that? Like, how? I understand the need for more resources to deal with these complaints. Like, was this not a priority before last year, or like how did you undertake what you're doing now prior to that extra funding, or you just didn't?
No. So firstly, there was a process of working with the RBA to understand so when the prohibition first came, to understand the charging processes and what data would be available. Then there was a scoping of where the practices were of most concern, and there were enforcement actions taken in that initial period. There was such charging occurring in larger companies, included, as I recall, airlines, telecommunications companies, ticketing companies, and actions were taken. As a result of that action, the ACCC's assessment is that the larger businesses understood they could not continue to do so. So there was a change in behaviour. That intervention caused a change in behaviour. Once it then became a question of small and micro businesses, then there has been elements of outreach. We have a small business team that engage elements of outreach to peak bodies to seek to identify. What this now allows us to do is to do that in a much more effective way, because you do, with small businesses, need to get out and about and to be able to much more broadly engage. And one aspect that we have raised in the submission, this prohibition, so it's not the disclosure point, that sits in the Australian Consumer Law, that is jurisdiction for the ACCC, and it's a multi-regulator model with the state and territory departments also regulators, and we work, Mr. Gress and his team work very closely with them. But this excess charging aspect in surcharging is only with the ACCC. So one of the other submissions we are making is it will be more effective to be able to reach more broadly, to also sit that in a multi-regulator model will assist.
Okay. Did you ask, just out of question, or did you ask or did you have a conversation with the former government about more resources in compliance in this matter?
I don't know the answer to that question, actually, because it's before my time.
And I also, I can't recall. We can take that question on.
Can you take that on notice? And could, if possible, you share, I guess, within the rules, obviously, your current compliance activities with the committee, if that's okay, and, you know, appropriately redact things if you have to or not, just sort of how many you're taking, the general nature of what they're for and who they are. So one last question. I just back to this blended pricing, I still find it extraordinary that this is how, I think this is a big part of the problem we face today, right? People are much more aware of surcharging because it is well known now that debit is very low cost, but when it's passed on as a blended price, it's a lot higher. And all this is known, it's public. So if I went to a retailer that charged a blended price higher than what I know it costs because of publicly available knowledge, and I put in a complaint, how would you investigate that? Because they're charging me 1.6%. I mean, Commonwealth Bank has a blended price of 1.1%. Some people have a blended price of 2.5%. That includes Qantas points to the merchant, right? But I know that a debit card costs me, I'm pretty confident the true cost of a debit transaction is about 1%. So if I put that complaint in, which I may or may not do at the end of this questioning, how would you?
It's like a Joe consumer complaint.
Like, because we're being overcharged.
So let me cover 2 points. Directly, the prohibition is on the merchant charging a price higher than their costs to be able to offer. And if they are being charged by their payment service provider a blended price or a single price, then it may not be higher than their costs. So absolutely understand the point you're making is that if you go up the chain, there will be fewer costs because there aren't credit, etc. elements in the cost, but fewer costs for a debit charge transaction. But so far as the merchant is concerned, that may actually be their cost. More broadly, and these are important questions that will be considered, as shown in the issues paper of the Reserve Bank, there are important questions about what the costs are, and there are also costs of accepting cash and increasing costs of cash being able to be available broadly at merchants. And so I'm not trying to say you're not raising an important question. It's a very important question, but there are important factors for you and for other members of the committee and for others in a policy sense. In a time when there is change happening, increasing digital, but still consumers who want to use cash, and whether it is actually appropriate for there to be some support from one set of payment mechanisms to others, which are questions of policy and also commercial questions.
So as the rules stand currently, it's almost carte blanche for these payment providers to bundle in a whole heap of things irrelevant to the cost and pass that on to the merchant. And if they pass that exact amount on, 2.5%, there's no recourse for the consumer.
The bottom line answer is yes, what you've just said is right. What I should, though, caveat is if a payment service provider is being misleading themselves to the merchant about the basis of their charge, we could look at that as misleading and deceptive conduct. If there are elements up the chain where the participants, particularly a credit card scheme or a debit card scheme, are not complying with the regulatory framework the Reserve Bank has in place, in the regulatory question. But if that's being met and there is proper disclosure happening, then the answer is yes to what you said, to your question.
Bit of work to do there. Thank you. Appreciate your evidence.